Imagine surviving war, crossing oceans, rebuilding your life in Britain, and then, 2.5 years later, a letter arrives saying your time is up. This is not a nightmare. This is the new UK asylum law of 2026, and it starts right now. Let us begin by understanding what came before. Under the old system, anyone who applied for asylum in the United Kingdom and was successful would receive 5 years of refugee status. After those 5 years, they could apply for indefinite leave to remain, commonly known as ILR, which meant permanent permission to stay in Britain. This system had been in place for decades, and hundreds of thousands of people built their lives in Britain through this pathway. It gave people stability, a sense of permanence, a foundation on which to raise children, build careers, and contribute to society. But now that picture has completely changed. From the 2nd of March 2026, a new asylum policy came into effect in the United Kingdom. Under the new rules, those who apply for asylum after this date and are successful will receive just 30 months of protection, 2.5 years, instead of the previous 5 years. This new status has been named Core Protection Status. The government is presenting this change as a fair but firm approach. But human rights organizations are asking a harder question. Does this change actually protect people, or does it push them deeper into uncertainty? The government's position is that this reform is intended to move away from the concept of permanent protection and toward a more temporary and conditional system of refuge, while still meeting international obligations. In other words, the government is making something very clear. Arriving in Britain does not automatically mean staying in Britain forever. When your home country becomes safe, the expectation is that you return. To truly understand the reasoning behind this policy, we need to look at some numbers. In 2024, a record 105,000 people applied for asylum in the United Kingdom. In the year before that, net migration stood at 649,000, though it has since fallen to around 200,000. Home Secretary Shabana Mahmood has repeatedly argued that the old 5-year permanent protection model acted as a pull factor, meaning people were incentivized to come to Britain because once they arrived, 5 years of guaranteed protection and then a pathway to permanent residency awaited them. The Home Secretary has said that this policy draws inspiration from Denmark's model, which has brought asylum applications down to a 40-year low, while in Britain, applications rose by 13% in the year leading up to September 2025. Now let us address the most important question of all. What happens after 30 months? This is the most complex and, for many people, the most unsettling part of the new policy. At the end of 30 months, the government will conduct a review. If conditions in your home country are still dangerous, you will receive another 30 months of protection. But if the government determines that your country is now safe, you will be asked to return. This process is called a safe return review, and the detailed guidance on how it will work in practice has not yet been fully published, which is creating enormous uncertainty for applicants. Importantly, from the 8th of April 2026, the Safe Return Review process will be formally incorporated into the immigration rules. Until now, it existed only in caseworker guidance, but making it part of the official rules means it becomes more formal, more binding, and more consequential for those it affects. There are also significant changes to the pathway to permanent residency. The route to indefinite leave to remain for asylum seekers could become much longer. Proposals suggest a baseline qualifying period of 20 years, though there may be provisions to reduce this period through contributions such as work or study. This is still at the proposal stage, but if it becomes law, the journey to permanent settlement in Britain will become dramatically harder for those who entered through the asylum route. Understanding who is affected by these new rules and who is not is absolutely critical. Those who have already applied for asylum or have already been granted protection are not affected by this change. Anyone who applied before the 2nd of March 2026 remains under the old 5-year framework. This is one of the most important pieces of information in this entire discussion. If you submitted your application before that date, the new rules do not apply to your case. The rules for children are somewhat different. Unaccompanied asylum-seeking children, those who arrive in Britain alone without a parent or guardian, will still receive 5 years of protection. This also applies to children who were under 18 when they applied, but turned 18 before a decision was made on their case. The government has said that longer-term policy for this group is still being developed. Another significant element of the new policy is the visa break mechanism. Under this new measure, restrictions have been placed on certain mainstream visa applications from nationals of Afghanistan, Cameroon, Myanmar, and Sudan. The purpose of this visa break is to close a pathway that some people were using, entering Britain through a regular visa and then applying for asylum once inside the country. By restricting access to these visas for nationals of high application countries, the government is trying to limit that route. Furthermore, from the 26th of March 2026, Afghan nationals will no longer be able to apply as the main applicant for a skilled worker visa. This is a significant restriction for many people who had been trying to come to Britain through legitimate work-based immigration routes. It effectively closes off a legal pathway that a number of Afghan nationals had been using to build a life here. There are also changes to asylum support, the financial assistance given to people while their applications are being processed. The government is seeking to remove the legal duty to provide support to asylum seekers and replace it with a discretionary power, meaning the government would no longer be legally required to provide support, but could choose to do so. This change is expected to come into effect in June. In practical terms, this means that financial support for asylum seekers could become less predictable and less guaranteed than it has been in the past. On the matter of family returns, the government has also launched a consultation process. A pilot scheme is being run that offers financial incentives, up to £40,000 per family and up to £10,000 per individual, to encourage families with no legal right to remain in Britain to voluntarily return to their home countries. Whether this approach will prove effective or cost-efficient remains to be seen. The rules around further submissions, what happens when someone whose asylum claim has been refused wants to submit new evidence or arguments, have also been tightened. From the 8th of April 2026, you will only be able to make a further submission if you are physically in the United Kingdom, your asylum claim has been refused or withdrawn, and you have no outstanding appeal pending. In most cases, you will be required to attend a service and support center in person to submit this application. If you fail to maintain contact, miss an appointment, or do not provide requested information within the given time frame, your case could be treated as withdrawn. This is a critical point. If you are in this situation and you ignore letters or miss appointments, you could lose your right to remain in Britain without even realizing it. English language requirements are also changing for those seeking permanent settlement. From the 26th of March 2027, applications for indefinite leave to remain will require evidence of B2 level English proficiency, up from the previous requirement of B1. This is a meaningful increase in the standard required. B2 level represents upper intermediate fluency, the ability to understand complex texts, express ideas fluently, and interact with a degree of spontaneity. For many long-term residents who never had formal language training, this could become a significant barrier to permanent settlement. Now let us turn to what the experts and human rights organizations are saying about all of this. Critics argue that 30 months of temporary protection is not enough time for people to rebuild their lives with any real stability. Think about what that means in human terms. You have fled a country torn apart by war or persecution. You have arrived in Britain, been granted protection, found work, enrolled your children in school, started, slowly, painfully, to build something. And then, after 2.5 years, you must again prove that you are still in danger. The psychological toll of that constant uncertainty, critics say, actively prevents people from integrating into society and contributing meaningfully to the country that sheltered them. Supporters of the new approach argue differently. They say that if someone's home country genuinely becomes safe, it is entirely reasonable to expect that person to return, and to use that space to welcome the next person truly in need of protection. They point to the enormous backlog in Britain's asylum system, and argue that the old model created a situation where the system was overwhelmed, resources were stretched beyond capacity, and the people who genuinely needed help were waiting years for decisions. But the critics push back with a fundamental question. Who decides when a country is safe, and how reliable is that decision? Afghanistan, Syria, Eritrea, Somalia. People from these countries have been seeking asylum in Britain for years, in some cases for decades. Their home countries remain dangerous in complex and unpredictable ways. A bureaucratic determination that a country has become safe enough for return may not reflect the lived reality on the ground. And if that determination is wrong, the consequences for the person sent back could be catastrophic. For anyone currently navigating the asylum system, or anyone who may need to in the future, there are some practical steps that are now more important than ever. The first and most urgent point is this: if you have not yet applied for asylum and you are planning to, do not delay. Those who applied before the 2nd of March 2026 remain under the old 5-year framework. That window has already closed, but understanding the timeline of your own case and acting quickly on any future steps is now essential. Second, if you are already inside the asylum process, stay engaged. Attend every appointment, respond to every letter. Do not ignore any communication from the Home Office, regardless of how confusing or frightening it may seem. Under the new rules, failing to maintain contact or missing scheduled appointments can result in your case being treated as withdrawn, meaning you could lose your protection status not because your claim was rejected, but simply because you did not respond in time. Third, know your rights and know where to find help. Organizations like Right to Remain, Refugee Action, and the Greater Manchester Immigration Aid Unit offer free, trustworthy advice. Never pay money to an unqualified or unregistered person who promises to help with your asylum case. Immigration fraud is a serious problem, and vulnerable people are often targeted by those who take money in exchange for false promises and bad advice. Fourth, if you are a parent or guardian of an unaccompanied child, or if you yourself arrived in Britain as an unaccompanied minor, remember that the rules for this group remain different. Unaccompanied asylum-seeking children still receive 5 years of protection, and this applies even to those who turned 18 before a decision was made on their case. To fully understand this moment, we also have to see it within a broader political context. Britain's current Labour government is operating under enormous pressure from multiple directions. On one side, there are international legal obligations, the 1951 Refugee Convention, human rights law, and the moral weight of being a nation that has historically offered shelter to those fleeing persecution. On the other side, there is significant domestic political pressure, with a large portion of the electorate demanding that immigration be brought under tighter control. The policy that has emerged from this tension is not perfect. No policy in this space ever is. But it is the current reality, and it is the reality that millions of people must navigate. What Britain is doing also sets a precedent that other countries are watching closely. Denmark did it first. Britain has now followed. The question being asked in policy circles across Europe is, who is next? And if more and more countries move toward temporary conditional protection models, what does that mean for the global system of refugee protection that has existed since the aftermath of the Second World War? These are not abstract questions. They have real answers that will play out in real lives over the coming years. A mother from Sudan, a teacher from Afghanistan, a doctor from Syria, a teenager who arrived alone at 16 and is now trying to build a future at 19. These are the people whose lives hang in the balance of policy decisions made in Westminster committee rooms and Home Office briefings. There is one final thing I want to say. Rules change, governments change, policies change. But the pain of a person who has fled violence with their children and crossed thousands of miles in search of safety does not change. Their fear does not change. Their hope does not change. And so, even in navigating all of these rules and timelines and review processes, we must never lose sight of the human being at the center of every case file. Know the rules, understand your rights, act on time, seek proper legal advice, and share this information with anyone you know who needs it. Because in a system this complex, knowledge is not just power, knowledge is protection.